Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate the public on a very interesting topic involving the termination of guardianship. So please subscribe to our channel. So let's talk about the termination of guardianships. It could be a termination of guardianship of a minor or not. Really, you have to understand what a guardianship is all about. First of all, by nature of the guardianship itself, it's not designed to be a permanent thing. The idea of a guardianship is that you get limited letters of guardianship designed to, keep you going for a little bit, and there's sort of a check back on these things. Do we need to renew letters of guardianship because the conditions that resulted in the need for guardianship continue to exist? Intrinsic in that notion is the idea that maybe they don't continue to exist. And if the reason why we set up a guardianship no longer exists, well, then, at that point in time, the guardianship might well be terminated. I'll give you a real easy situation. We have a minor. We have guardianship for a minor. The minor can't make decisions on their own, enter into contracts on their own, make specific medical decisions, for example. So what do? You have a guardianship, but now all of a sudden the person's 19 years old, 20 years old, 21 years old. Guess what? Probably don't need the guardianship anymore. So what do? We terminate it. Makes perfect sense. There could be other reasons for terminating it. A guardianship may come about as a result of a condition that happens outside the ordinary. In other words, it's not an aging condition. Let's say somebody's older and, they managed to break both their arms. And now they can't sign checks, they can't do anything, they can't handle their stuff, they can't function, and they need help all the time. For even to feed themselves, they need help. That's a person who's probably in need of some level of guardianship, some extra help. May need that. But eventually, when that person is cured of those conditions, there may not be a reason to continue the guardianship. If any of these kinds of things happen and the need to maintain the guardianship is no longer there, what has to happen is a petition should be filed with the probate court to terminate the guardianship. The court will conduct a hearing. The court will hear from anybody who opposes the termination of the guardianship. But the fact of the matter is, a guardianship to some degree takes the rights of one person and gives them to another. The court doesn't do that. The court doesn't take away your rights and give them to somebody else willy-nilly. There has to be a very strong reason for it. And upon a showing that it's no longer necessary to do that, the court is going to be quick to reinstate your rights. So if there is a legitimate petition filed to terminate guardianship, and there's no objection, and the court sees that the person is well able to care for themselves, the court will set that aside, terminate that guardianship, and that'll end it. Now, sometimes we find, particularly with elderly people, you may have an older person, a senior person who maybe falls and breaks their hip or something, so they get a guardianship, and then they're better. Their hip is healed, and now they say, I don't want the guardianship anymore. But the truth of the matter is there may be cognitive issues, there may be other issues that support the guardianship, and therefore there may be objection when that person decides they want the guardianship terminated. The court has to conduct a hearing to determine the propriety of those various competing claims. Each case obviously is very fact-specific. If you have a question about your case, reach out to us, and of course we'll be glad to give you guidance in that regard.